So our next panel discussion is on Fiji's experience with the Domestic Violence Restraining Order Act of 2009 and its subsequent amendments. How well are they working or not, and the challenges that are being experienced and how to overcome them. The session is scheduled for 35 minutes and it has been brought together by members of Fiji Women's Lawyers Association. Has the chair been able to join us? And if not, Mele, for example, would you be happy to introduce the members of the panel and step in to take on the chairing role? Sure.
Good afternoon, Ms. Foot, and welcome from Suva in Fiji. We're very grateful to be part of the panel discussions this afternoon. Our first panelist for this afternoon is Ms. Radhika Naidu, practicing with Reddy Law and Legal on London, which is based in Sydney and Canberra of Australia. Ms. Radhika Naidu has over 16 years of experience. She has worked primarily in a private law practice and has also been practicing in Sydney for about a year and a half. The second panelist is Ms. Swastika Narayan. Ms. Swastika Narayan owns her own law firm, Swastika Legal, and she was also a partner with Devan Prasad Lawyers, also a law firm in Suva, and Ms. Swastika Narayan has over 13 years of experience. Very grateful to have these two ladies working from two different time zones, Ms. Swastika from Suva and Ms. Naidu from Sydney, joining in to assist the Fiji Women Lawyers Association in being part of this workshop. I'll pass it over to the first panelist, Ms. Naidu.
Thank you, Mele. Greetings, everybody. And as Mele has said, I will be the first one to speak on this. We have split ourselves into 3 slots. So I'll basically introduce the Domestic Violence Restraining Orders and the Act, how it was passed and the background to it. And since all 3 of us have had personal experiences in terms of working with the private sector, we can all indulge in terms of our personal experiences and what our concerns or issues or recommendations could be in terms of proper implementation of the Act from here on. So without further ado, in terms of Fiji's Domestic Violence Act, then our Family Law Act was finally enacted in October 2003, came into effect in 2005. The Domestic Violence Decree at that time was passed in 2009. It commenced in 2010 with the intention to promote an equal access to justice by women. So post Fiji's military coup of 2006, it was the military government which had passed around 300 decrees, which subsequently became law. And fortunately, one of those decrees was the Domestic Violence Decree Now Act 2009. Although this act was not passed through a democratic process, the progressive nature of the Domestic Violence Act is a true reflection of all the joint efforts by Fiji's women's rights organizations, such as the Fiji Women's Crisis Center, the Fiji Law Reform, etc., which had prepared a domestic violence bill prior to the 2006 coup, which ultimately led to it being passed as a decree and now subsequently an act. So under the Domestic Violence Act 2009, a domestic violence restraining order can be sought in the High Court, it can be sought in the Magistrates Court, including in their family divisions, as well as in a juvenile court. The issue I see with this is that it has become a norm in Fiji for domestic violence restraining order applications only to be filed in the family division of the Magistrates Court. But when there is a breach or when it has to be set aside or discharged, then it again is only filed in the family court. So Fiji has got, Suva rather being the capital city, has got 2 family courts. The rest of the town and the areas have got either one family court, or it is the civil or the criminal court, which sits as a family court on a specific day of the week. So you do not have a fully operational family court in most of the regions, which hears these domestic violence applications on a daily basis. So regardless of the urgency of the matter, if one of the magistrates is able to accommodate that application, then they will do so. Otherwise, it will be pushed to the second day. So that is one of the issues when you really look at the objective And when we really look at how the application could be commenced on in which particular court it can be done. So this is becoming one of those serious concerns at the moment. Suva does not have this issue, but Lotoka has this issue, Ba has this issue, some of the other areas have this issue. Specific sections of the decree now act that I will look at. Section 6 of the act, this states the objects of the act, which is to eliminate, reduce and prevent domestic violence, to ensure the protection, safety and well-being of the victims, to implement the Convention of the Elimination of all forms of discrimination against women and on the Convention on the Rights of the Child and related conventions, and to provide a legally workable framework for the objectives. So no matter how commendable a new law is, and no matter how well it appears to set out a framework for equality, the proof of a law in itself is its implementation. So the way I see it, the challenge for our judiciary is that the reconciliation and the assault provisions that we had in the previous laws, which is the Criminal Procedure Code and the Penal Code, which has subsequently now been repealed, were implemented by these very same judicial officers who are now bound to implement the Domestic Violence Act. Under Section 19, this provides that restraining orders can be applied for by the victims, carer of the victim, a parent or a guardian of a child, a person who normally resides with the child who is the victim, children over the age of 16 years if they are victims, a police officer, a social welfare officer, the public trustee, or any other person where it appears to the court to be necessary for the safety or well-being of the victim. One issue with this is, do these other groups actually assist the victim? Do the civil societies actually assist the victim? A victim who is actually going through the trauma of being assaulted, faced in this situation of violence, she doesn't know where to go. She doesn't know the know-how. We as lawyers and as legal personalities, as NGOs, civil societies are well aware of these processes. If not, then we need to ensure that we are aware of this so that we can safeguard and protect the vulnerable. So if the Act already provides for these various parties, such as Section 19, as I have stated earlier, to assist with the applications, are we doing this? I think not, because most of the victims end up going to the legal aid commission or to private practitioners to assist with doing their applications. And in doing that, the assault or the violence that has already occurred 2 or 3 days has surpassed. So by the time the application is actually prepared and filed in court and presented before the magistrate, a number of days has since lapsed. And then the question that is normally posed to the applicant is there a genuine threat? Do you still feel that there will be a repeat of this offense? So these are some of the areas that we need to focus on in terms of ensuring that the victims are aware that there are a few other parties and a few other places that they can go to, can assist them in terms of filing these applications. The police as well can assist them, but the police officers do not have the domestic violence restraining order application forms at the police station. And one of the norms has become for the police to say, I will, instead of writing down the statement of the applicant, they will try to encourage reconciliation. I will discuss that a little bit further, but is that the role of the police? No. Another relevant section is our Section 25, which provides for telephone applications. This is one of those sections which is very much in the Act, but in my years of experience and practice in Fiji, I have not seen a single application being filed in the court or accepted by the court under Section 25, where an application has been filed via a telephone and an interim order has been granted protecting the victim. Is it because the parties are unaware? Is it because the applicants are not aware? We see that as a concern and should take it onto ourselves to ensure that the applicants, the public, are made aware that Section 25 is there, it is in the Act, and it is to safeguard the victims and the applicants. Section 26 also allows the court to make an application on its own motion. So this even goes to the extent of where there are criminal proceedings on foot rather, and the applicant who may be the complainant is related to the accused. So the court on its own motion can make such an application. And all these restraining orders have standard non-molestation orders, but additional non-contact orders can also be made under Section 29. Additional conditions are also provided for spouses under Section 30 and for children under Section 31. Section 31 gives the court powers to make temporary custody and care orders, although such orders can be subsequently superseded by the family court. So we have the relevant sections which actually assist the applicant in a situation where she's perhaps already pressed charges against the perpetrator for any criminal assault or violence. She can also request the court, or the court on its own motion can make a DVRO protecting her as well as the children in terms of making custody and care orders without the need for the applicant to knock on the doors of the family court and file relevant applications, which at times takes a while, and seek those necessary orders. It can be done in the same court at the same time, even on the first call of the criminal proceedings. Section 32 of the Act also allows the court to make orders in relation to personal possession. And Section 34 provides one of the most important orders, which is the orders for urgent monetary relief. This can assist the applicant in terms of urgent monetary relief / maintenance for herself and for the children. Fiji does not have and has not used safe houses as an option. So if Section 34 provides for such a relief, which is urgent monetary relief, this can be used as a tool and as a protection for the victim in the absence of there being a safe house. But our civil society groups are very vocal about this, and they have been behind the victims, they have been behind the applicants, providing whatever form of support they can, and which is very encouraging. And it is something that needs to be recognized by the stakeholders as well. And it is about time that Fiji should consider having safe houses for the applicants / victims. All proceedings are held in closed court, except where the proceedings or the applications are in relation to criminal proceedings. And Section 57 restricts the publication of these proceedings. So Section 57, to some extent, is a detriment to the legal fraternity as well, and to the judicial officers, because when proceedings are not published, you do not have access to those judgments. So there should be a way how to overcome this, because lately Fiji has decided that they'll publish the family court judgments, synchronize it, and not reveal parties of the names. The same could be done for domestic violence cases as well. Inter parte, ex parte, of course, it will be just granted. But inter parte matters, and where an application is made for a discharge, where an application is made for an amendment of the orders, where the parties have to go for a full hearing, these sort of judgments should be made available, at least to the legal practitioners, at least to the civil society groups, at least to the judicial officers, so that there is consistency in the form of judgments that are passed. So that brings us to another issue, is that why there are inconsistencies in the judgment that are being passed. Is it because one magistrate or one judge is unaware as to what was passed in another previous matter? Or is it because they fail to understand the objectives of the Domestic Violence Act? The police, on the other hand, they attended intensive training when the decree became an act in 2010. So the issue is, but are the police helping? Although the victims have had a right to complain when a police officer did not apply for a restraining order on their behalf, very few of them know that they have this right, and none are, and since they are unaware, they're not able to enforce this. Fiji had one of its first cases which came to the High Court in relation to the domestic violence decree, which was in 2010. This was in the case of Suresh Chand Maharaj against the state, 2010. This was a case which arose out of a criminal charge of unlawful wounding under the Crimes Then Decree Now Act. The victim was a de facto partner of the accused, and she was assaulted by the appellant with an iron rod. They were living together as de facto partners. She was reliant on him for his livelihood. He was a mechanic. When the assault occurred, she wanted to visit her father. The partner did not agree. She told her father to cancel the visit. The appellant, who was the partner, then struck her with the iron bar, causing a wound on the head, which required a couple of stitches. He was charged, and in mitigation, he told the court, which was in the magistrate's court, that he was the sole breadwinner and he has reconciled with the victim. The victim was present in court and she confirmed the reconciliation, but also said that other cases of the appellant, who was the partner, against her were still pending before the court. So the magistrate was well aware that although the parties are saying that there is a reconciliation, although there is a no-drop policy and reconciliation is not promoted in the Domestic Violence Act, the magistrate accepted the reconciliation as a mitigating factor and sentenced the accused to 18 months imprisonment. The sentence was well within the tariff for unlawful wounding. The maximum sentence for an offence under the Crimes Act is 5 years imprisonment. The magistrate did not make any restraining orders, nor did the magistrate consider the sentencing and the penalties decree in relation to sentencing for domestic violence. Subsequently, the decision was appealed, and Justice Gounder commented that it was unfortunate that the prosecution and the magistrate had failed to apply the domestic violence decree. As I had highlighted before, our Act allows for the court on its own motion to make such an order. The High Court then remedied the defect and held a separate inquiry into the need or otherwise for a restraining order under the Act. So this was one of the first cases where a domestic violence order should have been granted by the court on its own motion, although there were criminal proceedings there. And the parties had confirmed that they had reconciled, but the court had failed to do so. So the matter had to go on appeal so that this could be remedied. And these sort of decisions suggest that members of the judiciary are not enforcing the Domestic Violence Act the way that they should. It also suggests that prosecutors are not making relevant applications for restraining orders in cases of domestic violence, even though they are before the criminal courts. What is apparent from reading all this is that although these cases arise from a family relationship, and although sexual abuse is a domestic violence offense, the prosecution and the judiciary are not applying the Domestic Violence Act or the sentencing and the penalties decree to sentence such offenders. They, as in the prosecutors and judicial officers, have already attended training on domestic violence, and they continue to have such training on domestic violence. But why are they failing to implement the decree? Is it the attitude? Is it the attitude of this patriarchal society that we have? Because they see the eagerness to promote a reconciliation for domestic violence cases. The judicial officers continue to reconcile cases of domestic violence by accepting at face value the reconciliation which is presented by the victim in court. We do not know or are aware as to why the victim is appearing in court and saying that they have reconciled. They, as in the members of the judiciary, they do not go beyond this declaration or a written statement by the victim saying that I have reconciled to ask whether the victim is going to feel safe going back home and staying with the same perpetrator, whether the perpetrator has forced the reconciliation on her. This will show that there has been an ignorance on the part of the judiciary, because when a victim of an assault says she has reconciled and wants her spouse to be given a suspended sentence, does she know what she is really asking for? Does she know that she is going to be safe from future assaults? Is she there with certainty that the perpetrator is not going to assault her or the children? These are some of the things that has to be considered. The greatest barrier we can see in terms of implementing this Domestic Violence Act, as I have said, is the attitude of the prosecution, police, and the judicial officers whose task is to enforce all this, but it is not being done. The problem that the justice system must confront is why there are these problems and why the violence and sexual assault are being used to solve family problems. Is it because the bench is not gender balanced? Is it because we have male magistrates sitting there so that they are not able to see the common day-to-day problems that may arise between a husband and wife? So these are basically some of the issues that we basically face with our Domestic Violence Act. I will leave it to my other two colleagues to discuss in terms of the personal challenges that they may be seeing in terms of the act that we have.
Thank you. We'll now go on to our second panelist, Ms. Narayan. Over to you, Ms. Narayan. We have 15 minutes left.
Good afternoon, everyone. Are you all able to hear me?
Yes.
Okay. As we all know, in Fiji, the primary legislation covering protection orders is Domestic Violence Act 2009, and it's been in force since for the last 12 years now. I must say the act at the initial stages was a trial factor for a lot of litigants, but over the last decade, its application has picked up pace massively. One of the largest users of the act in Fiji is Fiji Women Crisis Center, who usually refer their clients through this act to court system. and of course, Legal Aid Commission of Fiji, and then we have private practitioners around Fiji as well who make use of the Act. The government department monitoring the laws and policies on domestic violence in Fiji is Ministry of Social Welfare, Women and Poverty Alleviation. National Domestic Violence Helpline set up by Fiji Women Crisis Center is a toll-free number 1560. If we look at the Act, it does specify definitions of certain terms, domestic violence, what domestic violence offense means. And like Ms. Naidu mentioned, Section 6 indicates the objects of the Act. To understand whether the Domestic Violence Act 2009 is working means to understand or knowing whether the Act is meeting the objectives. There are obviously certain underlying principles that the judiciary is required to observe when dealing with cases of domestic violence, so that they can, amongst other things, ensure a normal life of a victim, a normal life of a child who is affected, as well as the rights and obligations of a perpetrator towards the alleged violence. The Act aims for a speedy legal process, and there are standard application forms for that reason set out by the legislature to make it easy for individuals to apply. My personal account of some matters concerning DVRO is a bit odd. I would say odd because they mostly involve men as my clients, and they happened, I think almost all of them have been resolved without having the need to reach trial. But here are two situations that I have to share. Scenario one was a situation where I had defended an application for domestic violence restraining order, whereby the respondent was a man. It was a very tricky situation for my client. My client is a well-known businessman in Suva, and on this particular occasion, he had traveled to another island within Fiji to meet his business commitments for only 2 days. He was shown the standard DVRO taken by the applicant wife when he reached his date upon his return in the evening, and my client was thus not allowed entry into the house at night. On the very next day, we were sort of pushed to file an application to seek orders for our client to gain entry into the house, to collect his personal belongings and company-related books for his daily work. But the matter was resolved before our application could be heard. Now, this is a practical example which has 2 points of concern. One, the fear of reporting the matter. The applicant lady possibly feared the man and only gained courage to apply to court for immediate standard non-molestation orders when the husband stepped out of town. And the second point it raises is domestic violence happens in all types of families in Fiji and likewise everywhere, regardless of the economic and corporate status of a person and regardless of how educated a person is. Scenario 2 that I went across was, there was a case I handled where I represented an applicant man who was an aged father seeking protection orders against his daughter. The house was owned by the father, but the daughter created issues because she was living with her family with the father. The application had to be withdrawn because the application contained allegations that were too general. Now, this is a practical situation confirming that applicants sometimes may be undergoing a challenging situation at home, but their inability to express themselves clearly can affect their right to apply or seek a restraining order. Although we lawyers are there to assist the victims, but we can only do so much in certain situations. Domestic Violence Act 2009, as mentioned earlier, works hand in hand with Crimes Act. And so applications under Domestic Violence Act are tribal both in family and domestic court jurisdictions. There are 2 case authorities that I have picked up. In the case of State versus Peters, it's a 2016 criminal case where the accused was charged for assault occasioning actual bodily harm, contrary to Section 275 of the Crimes Then Decree, and 1 count of breach of domestic violence restraining order. So the court found him guilty, and as a result, the person was sentenced to 12 months imprisonment, whereby considering his family situation, he was required to serve 4 months in prison and remaining 8 months suspended for 3 years. For the safety of the victim, permanent DVRO was also issued. This case portrays that a case may have a very, very severe situation, but then the family situation of a person does have an impact on the end judgment that is passed. In this situation, the respondent father had 5 children to look after, and that is why he was only imprisoned for 4 months. The second case is RR versus FB. It's a 2013 Fiji Magistrates Court decision. It was a domestic violence matter. This is a strange situation. The applicant and the respondents were stepsisters. Interim domestic violence restraining order was issued against the respondent and her husband, particularly for harassing the applicant and her 2 sisters. So the orders were made against the respondent's sister after she was found guilty in terms of protection under Section 27, which is non-molestation orders, Section 29, which is non-contact orders under the Act, Section 32, which was use of possession, Section 33, meaning use of weapon, and under Section 36, which was occupancy order of the house, because this was a dispute arising from the house. So this case goes to tell that domestic violence cannot be an issue only between a husband and wife or parents and children. It can even arise between siblings. So anybody can be an applicant, anybody can be a respondent. Now, in my view, looking at Fiji's justice system, several cases are filed and several determined by courts around every month, which tells us that the Act is working in terms of reporting the matter to quite an extent. But the question remains as to whether the Act is working in terms of eradicating or minimizing domestic violence. Our NGOs are working so hard to tackle this problem, but why yet again there is so much violence? There have been workshops held around. Fiji News has also made news internationally up to Al Jazeera, where the contents and the stats have been discussed to a large extent, but the question remains, why does the rate still remain? Now, from 2020, one of the reasons has been pandemic. Domestic violence has arisen largely last year and this year, but then pandemic is one of the reasons only. Domestic violence rates have been rising from previous years, and they have been on high stats all the time. So in Fiji, in my view, a lot still needs to be done out there to make our current laws more enforceable. The penalties for breach of DVRO are perhaps not strong enough to instill fear in the perpetrators, and definitely more awareness needs to be made with police officers so they can assist in a more timely manner. Thank you.
Thank you, Ms. Narayan. Now, adding on to what the 2 panelists have stated, Ms. Narayan and Ms. Naidu have talked about the introduction, how well or not the Act is working, and they've also shared their personal insights using cases and their personal experiences. I think I only have about 5 minutes left, so if I may, I will go straight to some of the challenges that we have, adding further from the insights from Ms. Naidu and from Ms. Narayan. Some of the challenges that Fiji faces in the enforcement of the Domestic Violence Restraining Act 2009 is that the stakeholders that are in place, for example, when you get a domestic violence restraining order, it is treated as urgent by the courts in Fiji. So you can go to any of the courts in Fiji. The registries will help the applicants to fill out the form, and they file it and they appear before the courts and they give evidence. But when you get the protection orders or the DVRO orders from the court, the orders need to be served on the persons that that the applicant is seeking protection from. In one of the cases that I handled, I noticed that it was several months and the respondent had still not been served with a DVRO order. Now, what that means is that if there is a breach of the DVRO order, the criminal prosecution cannot commence because the order has not been served on the respondent. So then the purpose of getting the DVRO in the first place is futile, and the orders are often served by the police. So we note that in 2020 and in 2021, because of the pandemic, the excuse by the police force, and I understand they have a lot on their plate, the excuse by the police force is that they are trying to deal with the restrictions imposed by government. So the challenge there is, what about if there's another issue that'll come up apart from the pandemic? The police will then use another excuse, and we will see. We note that according to the findings from the Fiji women's rights movement, we note that there has been an increase of domestic violence between the years of 2020 and 2021, specifically during the periods of the pandemic. So if we have women that are the bold women or the bold applicants that are coming to court to apply for DVRO are coming to court, and we do not have these orders being served expeditiously by the police, and very similar to PNG, and I also heard another panelist say there's often only one police officer in a police station. For example, if it's Rewanga, a suburban area in Fiji, there's one police officer that handles DVRO. We have to continuously call that one police officer to see whether that police officer has served the DVRO order on the respondent, to make sure that the applicants that we act for are protected. The other issue that I think Ms. Naidu had already said is that there is some concern about the judiciary not enforcing the DVRO. And we also see that, apart from that, we also see that some of the magistrates are also, we also see that some of the judicial officers are also making progress with some of the statements that we made. For example, magistrates deal with hundreds to 200 cases per day, but they also are aware of the frequent offenders. So they have the discretion to send applicants. I see certain courts doing it, like, for example, certain courts in Asinu that send perpetrators within. They send them into remand for 2 or 3 days to make sure that the applicants are protected as soon as they are breaches. Because one part is to get the DVRO order, and if there is a breach, a criminal charge is then filed. So here we need the police to assist us. And if the police are busy with other work, like, for example, manning the different, for example, we had containment areas during the pandemic. When they're busy doing that and other work like patrolling the streets of Suva and other parts of Fiji, we see that they are not able to cope. So we see that the law is in place. So for Fiji, we have the domestic violence, we have the act in place, we have the crimes decree in place, the crimes act in place. But we see that the stakeholders, the officers that are supposed to assist us, are not helping. And so we need some research into that. Another thing that we see about and I think I only have a minute left, another challenge that we see with the domestic violence is the research would assist us insofar as some abuse is concerned. For some of the cases that we handle, where we're defending the domestic violence, we see some of the applicants are not applying for the purposes of protective orders. They are applying for DVRO for the purposes of property preservation and other disputes. So having some research, and we're grateful to Fiji Women's Rights Movement for carrying out a lot of research in this area. The research could help us to see how well we can improve the system. We want to make sure that the people that are accessing the court system for DVRO are getting the best protection that they can get. But we also need to make sure that there is a fine line, a fine balance with the system not being abused for the purposes of property preservation. Just last week, a case that I did, a lady applied for an urgent DVRO to get property, to obtain property from her husband. When the court gave her the order, she said, I want to take the property, but I want to still remain on the property. So the court had to dismiss the application because the process was being abused for the purposes of property preservation. Now, these cases may be a few, but we still need to do research to find out how we can make sure that the system is good to protect the people that are accessing the court system. That's about my contribution, unless the two ladies would like to add to, I think our time is almost up. Thank you.
I do notice that some of the questions in the chat, they've been answered by the panel members, so that's really good. I really appreciate that. So I just want to thank you very much for your contributions, Ms. Rakai and Ms. Naidu and Ms. Narayan. It was very, very interesting to hear about what's been happening in Fiji and your personal experiences. So thank you. We really appreciate it.